Private Members Bill, Criminal Law Incest Amendment Bill 2012, second stage, item number 46, and I call on Deputy Naughten.
Less Concorda, I move that the bill be now read a second time.
Thank you.
Less Concorda. 5 years ago, Roscommon Circuit Court heard the shocking details surrounding the sustained abuse and neglect of 6 children in one family. At the time, Judge Miriam Reynolds questioned how the situation could have gone on for so long, given the fact that the children were in school and also given the family's involvement with the Health Board. Yet, after being failed by the state institutions for years, these children were once again failed by both the law and the Oireachtas. At the sentencing hearing, the late Judge Miriam Reynolds said, "The Punishment of Incest Act of 1908 is 100 years old. At the time, it was not even contemplated by legislation and possibly by society that a woman, a female, could commit incest as the perpetrator or instigator of such an offence. The provision was a person who had carnal knowledge of a female was guilty of a felony and liable to life imprisonment. Section 2 stated that a female person aged 17 years or above who permitted a grandfather, a father, a brother or a son to have carnal knowledge shall be guilty of a misdemeanour and was liable to a prison sentence of between 3 and 7 years. In this particular case, rather than the issue being that of whether a female consented or not, we had a woman who was the perpetrator and the instigator. At the time, the judge said, "I believe all persons should be treated equally before the law." She went on to say, "Had she been male, she would have been facing up to life imprisonment. Clearly, right-thinking society could not comprehend such a desperate act, hence the lack of regulation. But this lack of regulation could have been addressed in 1993 when the 1908 Act was amended on foot of the sentencing in the Kilkenny incest case, or when it was subsequently amended again in 1995 by making the offence apply to both sexes. The woman sentenced in the Roscommon Circuit Court case 5 years ago became the first and hopefully the only woman in the history of the state to be convicted of incest. On the 27th of January in that year, then Deputy Shatter, Minister Shatter, moved a motion in the Dáil following the shocking and disturbing revelations exposed on foot of that case, including the gross failures of the Western Health Board to appropriately intervene at an early stage. At the commencement of that debate, we were all warned that the motion makes specific reference to matters which were the subject of criminal proceedings and in regard to which further proceedings were expected at that time. By the issue of sentencing and the courts was avoided at that stage due to the fact that a male had yet to stand trial. The fact was that we were all in this House appalled at the sentencing restriction. However, commenting on the sentence, family law expert Geoffrey Shannon said, "Existing legislation should be reformed to provide an equal sentencing for men and women convicted of incest." At the time, the then Minister for Justice, Dermot Ahern, was reviewing the criminal law governing sexual offences for the purpose of providing greater protection to children and other vulnerable persons against sexual exploitation and abuse, including a review of the need to reform the incest laws. It was subsequently decided that a provision to increase the penalty for incest by a female to life imprisonment in order to bring it in line with that of a male would be incorporated into the reform of the criminal justice sex offences legislation. And we are now waiting for action on that 5 years later. The general scheme of the Sexual Offences Bill, including this reform, was approved by Government before Christmas, and Minister Hayes here in the House last October had said that it would have been approved by the end of October by Government, but it did happen before Christmas. After that Cabinet decision, Minister Shatter announced on the 17th of December last that the general scheme of the bill would be published by the end of January. We are yet to see the general scheme of that bill, and the fact remains that it will take some time before it becomes the law of this land. 21 years ago, there was public revulsion when a man, a so-called father, was sentenced to a maximum 7 years for incest in Kilkenny. The Oireachtas acted quickly and increased the maximum sentence within weeks, and again revisited the issue 2 years later. So before that individual was due to be released from prison, the law had been revised twice. Yet here we are, 5 years after the sentencing of a woman, a so-called mother. We are still awaiting for a change to the law. I don't question the bona fides of Minister Shatter or his commitment to reform this law, but it is taking far too long. That is why 2 years ago I published this legislation, the Criminal Law Incest Amendment Bill 2012, which addresses the 21-year legal loophole that sees men liable for life imprisonment if convicted of incest, while a woman faces a much shorter maximum sentence. In order to address this anomaly and ensure equality of treatment of sentencing in incest cases, this bill proposes to increase the maximum sentence available to judges in respect of females to a term of life imprisonment, so that the law no longer makes an irrational distinction between male and female perpetrators of such horrific offences. This bill amends the Punishment of Incest Act of 1908 by amending Section 2 of that Act, by substituting the word felony for misdemeanour, and for substituting the words to be imprisoned for a maximum term of life for the words to be kept in penal servitude for any term not less than 3 years and not exceeding 7 years, or to be imprisoned with or without hard labour for any term not exceeding 2 years. 10 words, that's all that I'm looking for. 10 words to ensure that the option of life imprisonment is open to judges upon conviction of either a male or female for the inhumane act of incest. This change in the law is needed now, not sometime in the future. That is what the family at the centre of this case wants. It is also galling to see that while the law has been changed twice since the Kilkenny incest case, and both changes happened in advance of that offender's release from prison, in the Roscommon situation, the perpetrator will be released in advance of any change in the law. While this has no bearing on the sentence served by those already convicted, it does at least help the victims, who can see that their tragedy is being taken seriously by the legislature, and with the view to ensuring that no one else can receive such a light sentence in future. Just 10 words. 21 years this legal loophole on incest has existed. Let's make sure that it doesn't run into 22 years. And I do, as I say, accept the commitment here of the Minister to reform this particular aspect of the legislation, but not just this particular aspect of the current law, but reform the law in relation to sexual offenders in this country. The present law in this area was enacted by the Oireachtas back in 2001, and we've had a review that took place in 2009. And on foot of that, we've been promised the legislation, and in fairness to the Minister, he has progressed this legislation since he has gone into the role as Minister for Justice. But I think it is important that we do address not just this particular issue, but other gaping loopholes that are within the sexual offences legislation. One of those is in relation to the Sex Offenders Register. At the time of the sentencing in the Roscommon case, Judge Reynolds also ordered the defendant to be placed on the Sex Offenders Register. And I want to turn to that issue for a minute. Presently, An Garda Síochána have a system in place for the monitoring of all persons subject to the notification requirements, the so-called Sex Offenders Register, under the Sexual Offences Act of 2001. The Domestic Violence and Sexual Investigation Unit monitors and manages the notification provisions and maintains all information relating to persons who have obligations under that Act. Just over 1,300 persons are monitored by An Garda Síochána on an ongoing basis. There is a nominated Garda inspector in each Garda division who has responsibility for monitoring of persons subject to the requirements under the Act within his or her division. All sex offenders are required to notify an Garda Síochána within 7 days of their release from prison that they have been convicted of a sexual offence and provide their name and address. They must also notify of any change in their name and address and must give notice of any intention to leave the state. The duration of the post-release notification requirements vary depending on the sentence received. It ranges from a 5-year period of notification for non-custodial sentences to an indefinite period for sentences of over 2 years. Failure to notify is an offence that is punishable by up to 5 years imprisonment and gives rise to the powers of arrest without warrant. But the current system of monitoring sex offenders in this country just isn't working. And if we look to the Central Statistics Office statistics for sex offenders breaching those particular rules, in 2009 there were 24 breaches recorded. It was double that in 2010, where there were 50 breaches recorded. In 2012 there were 59 breaches, or in 2011 there were 59 breaches recorded, and in 2012 similar figures in relation to the breaches. We have a situation where there are about 100 sex offenders discharged from prison on an annual basis. We have 6 prison staff that have responsibility for performing risk assessments on the whole population, not just including transfers, temporary releases, early releases, not just dealing with sex offenders. And we have a situation where the sex offenders register in this country. There's 1 recorded breach for every 5 people that are on that register. 1/5 of the persons on that register have been at one stage in breach of the conditions of the sex offenders register. And I think it's important to remind the House that the conditions of that register are, for breaching that, is 1, to not tell the Gardaí, to tell any Garda station in the country where you're actually living, or not staying in your designated address 1 out of every 7 nights. Very simple conditions, and yet we have 1 in 5 breaches of that. And the reason for that, I believe, is the system is hugely lax as it stands at the moment. There are major loopholes in relation to it, some of which I have raised here in the past. One of which was raised by Minister Shatter's predecessor, Dermot Ahern, in 2009, when I raised the issue of the 7-day notification period. Because the situation in the UK is that once someone is released from prison, they must notify the authorities within 3 days. If they change their address, they must notify the authorities within 3 days. Here, it's 7 days. And at the time, back in 2009, Dermot Ahern told the House here that unless this particular specific loophole is closed off, that Ireland could become a safe haven for convicted sex offenders. Now, that's 50 months ago, and yet convicted high-risk paedophile can visit Ireland from Britain or Northern Ireland, unknown to the authorities here, and roam around the country legally for 7 days. It is just not good enough that that particular anomaly continues to remain within the statute. We've had numerous instances where people have been sought in the north in relation to offences, may have already been convicted in the past for sexual offences, and have been found residing here in Dublin. And I think it is imperative that that particular loophole that is in the statute needs to be closed off, and needs to be closed off as quickly as possible. But I want to say that in relation to this horrendous case that took place in Roscommon, that some small good if you could call it that, did come out of it. I think it highlighted some of the good aspects of An Garda Síochána, particularly the work of Sergeant John Hines, through his tremendous dedication, not only in bringing this particular case to light and to conviction, but also other similar cases that he has pursued over his career. And I know that Sergeant John Hines has been recognised by An Garda Síochána for the tremendous work, by his colleagues within An Garda Síochána for the tremendous work that he has done in that area. But at the time of that particular case, he also singled out the family, because he said there was great credit due to each member of that family who brought the offences to the attention of the authorities and facilitated that prosecution and conviction taking place. But I also think that that particular family, exposing what they did expose, ensured that we reviewed how we handled child neglect cases in this country. And on foot of that case, there was an audit, a pilot audit in 3 areas, one of which was Roscommon, into how neglect cases were being handled. It identified, in relation to County Roscommon, 7 families out of the 30 families that were looked at where there weren't adequate provisions being put in place to protect children in that situation. That audit of 3 areas identified 17 families in total where they'd been failed miserably by the state. And remember that that only represents a small snapshot of the numbers of neglect cases in this country.
2 minutes.
So there are 17 families who have directly benefited on foot of the audit that took place. And on foot of that particular pilot, the Minister herself has now directed the HSE to review all neglect cases in the country. And I believe that hundreds of families will be saved on foot of the review that has taken place, and that is purely down to the fact that these particular children were brave enough to come forward. Before I finish up, I want to acknowledge the assistance of 2 people who helped me in relation to the drafting of this particular bill. And they're Jill Mellor in my own office and Brian Hunt. And without whose assistance, this bill wouldn't be before us here today. In conclusion, last Concordia, I want to say that the objective of this bill is to ensure that through our laws we protect those who are the most vulnerable in our society, our children, and all victims of such horrific crimes. We owe it to the children at the centre of the Roscommon case to ensure that their courage and their bravery is recognised. No other family should be failed by the state to the extent that this family were. Judge Miriam Reynolds said, "There are 6 lives that have been destroyed, and there is no other way of saying it. They are all victims of abuse. The woman who gave birth to them will cast a long shadow over their lives forever. Let's ensure that this law can reduce that shadow somewhat. Let's ensure that we can close off this loophole once and for all and ensure that we can act to ensure that the law does reflect the abhorrence that we all have of this particular offence."
Margaret, I now call the Minister for Justice.